Good afternoon. This is Laws 12062, Dispute Resolution. It's week 5 and we're dealing tonight with conciliation, which in relation to the Spencer publication is pages 125 to 129. Conciliation and mediation, very similar in appearance. I will invite anyone that wishes to make any statement about the difference between mediation and conciliation to provide a commentary instead of just me talking all the time. That's if you wish to. While we're doing that, while you're collecting your thoughts, I just wanted to speak to you about NADRAC. You've probably seen this acronym, NADRAC, which is the National Alternative Dispute Resolution Advisory Council, or at least it was. It was disbanded last year to simplify and streamline processes. Realistically, the official reason was that the work has been absorbed into the Federal Attorney General's Department. Many of those non-statutory bodies have outlived their original purpose or are not focused on government policy priorities. As a result, their work is best carried out by the relevant government department or agency. So that's the demise of NADRAC, which was established in 1995 as a statutory body to provide expert advice and policy to the alternative dispute resolution industry, if you like, and promote the use of ADR generally. So NADRAC concluded, I suppose because of cost reasons, it did establish the Mediator Standards Board and the National Mediator Accreditation System that you're all familiar with. Now, no doubt many of you have started your assignment in relation to the accreditation process, and you may have come across NADRAC, but I just thought you should be aware that it's now been disbanded if you haven't already picked up on that. So that all came about as a result of some reports. Going back to 2009, there was the Access to Justice Task Force report, which led to the introduction of the Civil Disputes Resolution Act in 2011 and emphasised the need for genuine attempts at ADR before legal proceedings proceeded further. Now, I'm just going to mute your microphone, Catherine, but feel free to come in and ask a question or comment. And having done that, maybe you were about to tell us the difference between conciliation and mediation. I'm not sure. Now, does anyone want to provide some commentary? Nicholas is saying yes. Do you?
Sorry.
You're right there.
Yeah, it looks like that the main difference between conciliation and mediation is what the facilitator will actually do during the dispute process, whether they offer any guidance on resolution options or what the fleshing out parties' interests. That type of stuff in conciliation, whereas mediation, they'd refrain from doing that.
Absolutely. Great. Great answer, Nicholas. Does anyone else wish to offer an opinion or provide a statement? And thank you for that. It's like Ferris Bueller. Anyone? Anyone? You're probably...
hello.
Yes, hello.
Hi, John. Can you hear me okay?
I can, John. Thank you.
Oh, good. Look, I was just thinking that just from what I was reading, that conciliatory was more kind of interventionist, perhaps. It was a bit more forceful than, the classic mediation model.
Mm-hmm. Absolutely. Yes, I agree with both those answers, so thank you. Anything else that you wish to add, John, or anyone else? And you do know that reference to Ferris Bueller, don't you? Anyone? Anyone? You're all probably too young. Thank you, Naomi. All right, let's move on then. Now, before anything else, in a sense, we had conciliation. It goes right back to the Constitution, in fact, where one of the powers in Section 51 conferred upon the Commonwealth Constitution was to make laws in relation to conciliation and arbitration. So even though I've said that ADR is a new process in law, and it very much is, we did have right back then conciliation, and that was relevant to workplace function. It has been adopted in formal process by a number of organisations. If I could probably say mostly under the term of conciliation by Commonwealth agencies, it seems to me. So I've got a list here. You've probably come across this if you've been doing some research. The Australian Human Rights Commission, which deals with disputes in relation to age discrimination, sex discrimination, rights and freedoms, asylum seekers, etc. So conciliation is used at the Human Rights Commission. The Federal Administrative Appeals Tribunal, the Family Court of Australia, if there's disagreement about financial issues, occasionally parenting, but primarily for financial issues. The Fair Work Commission, Commonwealth body again, dealing with unfair dismissal disputes, they use the term conciliation. The Superannuation Complaints Tribunal, federal again, assisting in resolving disputes between complainants, superannuation providers, and other joined parties. We see that in the context of disputes in relation to the way in which superannuation payments have been made following death. And just as an aside, you know, we think in terms of estates that we don't tend to think about superannuation as being an asset, and it really is separate to what can be left in a will. Anyway, that's an aside. Other bodies that deal with conciliation, the Financial Ombudsman Service, again, Commonwealth offering free service in terms of resolving disputes relating to customers in financial products. The Department of Justice and Attorney General, this is Queensland, the Office of the Commissioner for Body Corporate and Community Management, dealing with body corporate disputes. They then go to QCAT if they're not resolved at BCCM stage. And then private organisations such as universities might use the term conciliation. So conciliation is really, as identified correctly by Nicholas and John, it's mediation but more. It's mediation where the conciliator is expected to offer an opinion in terms of some prospects, and also is much more interventionist. So I agree with both those summations. So if we go back to NADRAC, which came up with a definition of conciliation, it essentially runs like this. It's interventionist mediation, a bit like a compulsory conference at QCAT. We call them COCOs. So a compulsory conference at QCAT level is really conciliation. So conciliation is a form of ADR, says NADRAC, where with the assistance of the conciliators, the parties identify the issues, well, that's like mediation, develop options, and that's like mediation, consider alternatives, that's like options, like mediation, and endeavour to reach an agreement. So for the first part, A, it's just really much like mediation. We try to find out what the issues are, think about the issues rather than the positions, develop some options, consider alternatives, and try and resolve it. Second thing about conciliation is that the conciliator may provide advice. And as we identified, that's a major departure from the pure mediation model, which is intended to be non-interventionist. The third aspect of conciliation is that the conciliator may have professional expertise. It's not a mandatory requirement, and that's not to say that someone with professional expertise wouldn't be involved in a mediation, but because mediation is non-interventionist, there's less chance for an expert to demonstrate that skill, as is the case in conciliation. The next is, conciliation is similar to mediation, save for the conciliator's role as being more directive and more advisory in a sense. Number 6 is conciliation may be voluntary, court-ordered, or required as part of a contract, whereas in its pure form, mediation is only voluntary. But can I just say the pure form doesn't exist all that often in mediation. And very often we have almost a hybrid between a mediation and a conciliation in practice. The sixth thing is that conciliation is often part of court, tribunal, or government agency process. Okay, so number one is like mediation, try to sort it out. Number two, the conciliator can provide advice. Number three, the conciliator may have professional expertise. Number four is really a summation of that it's similar to mediation, except the conciliator is more directive and advisory. 5, conciliation can be voluntary, court-ordered, or part of a contract. And number 6, it's often part of the prescribed process on the way through. So any questions at this stage? Anyone wish to make a comment? That'll be a no. All right. So when is conciliation suitable? I've got a list here. Where the participants have a dispute that can benefit from the intervention of a third party. Well, that's true of mediation, I guess, too. Probably true of most disputes. But that's a prerequisite. Conciliation, we've got a dispute and it would be advantageous to have a third party. Second, when is it suitable? Probably suitable if it involves technical or legal issues. And that's where the role or the expertise of the conciliator can come through. Number 3, the participants welcome some advice, they're looking for some assistance, but they still want to maintain control of the process. Alternatively, they could simply go to court or the tribunal and say, look, we'll put our case forward, you just tell us the answer. Ideally, conciliation is in that situation where they want more than mediation. They do want a bit of technical input. They do want a bit of direction and a bit of advice. But they don't want to go all the way to a decision. They would like to maintain control to some degree. Number 4, the participants want to keep the discussions confidential. Of course, if you go to a court or tribunal, generally speaking, it's on the public record. It's available for the media, for other parties. So, you can imagine that conciliation is advantageous, let's say in a financial dispute situation where, a financial planner may not want to have the adverse publicity that might be associated with an adverse finding in a tribunal, for example. The next one is conciliation is suitable where the primary mediation was not successful and the parties want to take it to the next level so that it's more directive without going to that final step of going to court. And finally, conciliation is useful or suitable if the parties don't want or don't have legal representation. So they might say, well, we're not really entirely sure what the legal position is, so let's go to conciliation. And if we have an expert legal practitioner who's the conciliator, maybe we'll get some free guidance and give us a better idea as to what's likely to happen in the event of it going to court or tribunal. Now, I'm going to keep stopping and inviting anyone to make any comments, ask any questions as we go. So keep that in mind. And if you do have a question, just interrupt me through that chat function or just unmute your microphone and come on in. All right, so that's when I think conciliation is suitable. The next one is a conciliator does not take sides or make decisions, and that's like mediation. And that's pretty obvious. The conciliator needs to be neutral. That's still a hallmark of ADR. It's not going to work if the conciliator is regarded as being biased. But at the same time, even though the conciliator might make some recommendations or provide some opinions, still not going to make the decision. So may advise, but will not make the decision, will not determine who's right or wrong. Conciliation is still a flexible process. There are many ways that conciliation can be undertaken. Does anyone wish, and I'm going to put it back on you all collectively, So get on your thinking caps. Does anyone have any ideas on how conciliation can actually take place? If you get in early, you get the easy ones. Does anyone wish to tell me how conciliation, from a practical point of view, how does one undertake conciliation? I'm looking across. I don't see anyone unmuting their microphone. All right. I'll go through a list. Tell me if I'm wrong. Tell me that I've missed some. Conciliation may be at a really basic level through exchange of letters. So we have the expert involved. I mean, let's say it's a, we'll go back to that list of people that do mediation. Financial Ombudsman Service. So someone's got a dispute with their bank. They've taken it to the Financial Ombudsman Service. It might be that the conciliation takes the form of letters and try to resolve it that way. Or maybe over the telephone, just a telephone negotiation as opposed to a full-on conference. Or it might be a full-on conference but done by telephone. It could, of course, be face-to-face conferencing. As a different way of doing it. All right, so it's a flexible process. There's lots of different ways to do it. Now we've talked about this process, but let's go through it again. Very similar to mediation. In conciliation, like mediation, Paul Rigby, meeting of representatives. Exactly, could be that as well. Thank you. That's a different form of conciliation. All right, so what's the process? Like mediation, we have typically the opening statement by the conciliator, identifying what the role of the conciliator is, what the role of the parties is, explaining the process, and setting out the ground rules. So very much like mediation. Following that, again, like mediation, the parties make their opening statements, try to keep it relatively short, try, if possible, as the conciliator, to move them towards the issues, because what you hope to do from that opening statement on both sides is you hope to create the agenda, just like mediation. At that stage, as the conciliator, try to take control. Remember, what you're aiming to do is become their new best friend, both sides. Keep control of the process, keep calm, keep friendly, listen very carefully, and in conjunction with the parties, where you're trying to avoid them interrupting each other at that opening stage, we then obtain enough information to create an agenda. Once we've got that agenda, maybe 4 or 5 items typically, we'll move into the joint session, just like mediation. At this stage, we then start to encourage some communication directly between the parties. We try to ensure that the parties understand each other's position. From that, we hope to generate some options for agreement. Now, that's mainly the parties, but here's the first difference between mediation and conciliation. In the conciliation, it's perfectly appropriate and probably necessary for the conciliator to generate some options, and maybe the conciliator came up with an idea for the agenda item as well. In a pure mediation situation, that should never happen. Any questions so far about the difference in procedure between the two? No questions? Yes, John?
Yes, John. I was just thinking how it is really quite a big departure. When you've got the pure mediation, you're not sort of getting in and making proposals for settlement or anything like that.
Yes.
And, when you're conciliatory, it's actually the power of the conciliator, or whatever you want to call it, is now starts to impact on the settlement. So their power now is part of that, where there was no power when it was just, say, a pure mediation. And that's where I could imagine that, once you give someone power, they can start kind of setting the agenda. They might say, oh, look, we just don't have time to get to the real issues. And all of a sudden, a mediation process has really shifted quite significantly. And that's just something I was just thinking about.
Look, that's an excellent point, and you're quite right. And the conciliator does does maintain a lot of power there. It can easily assist the process, but it can go the other way as well. And in ADR, mediation and conciliation, we still want this dispute to be owned by the participants. So conciliation doesn't take it away. So by intervening that third party, the conciliator, in the way that you've correctly identified, there is a real risk that it can be taken away from the parties to a substantial degree. So thank you very much for that contribution, John. That's spot on. Anyone else wish to add anything in terms of the procedure to be adopted by a conciliator and highlight the difference between it and mediation in doing so? All right. And Blade's joined us. Thanks, Blade. Okay, so we've said that we then have this joint exploration session between the parties. We then typically go into private meetings. No surprise there. That's exactly the same as mediation. Maybe a little bit more forceful, again, in the private sessions. That is the role of the conciliator as opposed to the role of a mediator. So in that private session, again, not to be communicated to the other side without very specific instructions to do so. The conciliator will be looking to reality test. We'll generate some options. We'll talk about weaknesses in that party's case. And really we'll be quite candid in terms of saying, look, my assessment, for what it's worth, is that if the matter goes to trial and it's dealt with by someone like me, I think this is the sort of outcome you can expect, or at least this is the way I would probably decide it if the matter was was in front of me. So you can be really, as a conciliator, quite involved in that process, and that's where you really do get to highlight your abilities in a technical sense to supplement your abilities as an ADR practitioner. Now, I mentioned that anything which is said in those private sessions should remain in confidence unless you have very specific instructions to communicate that. Can I say that the only time I'm really comfortable in ever communicating anything in a private session is where it's a shuttle mediation or a shuttle conciliation. And you remember we talked about this last week, I think, briefly, where the two parties are entrenched physically in different locations, and the mediator or the conciliator or the conference convener, whatever it is, the ADR practitioner, moves between the two. But ideally, after a series of private sessions, and we go back into joint session, I then encourage the parties to be involved in communicating with each other to try and resolve the matter that way. So any questions about what I've said? And I know I'm moving pretty quickly, but if you're following, that's fine.
I've got a question.
Yes, Catherine?
I've got a question. You were just talking about conciliator being forceful. I was wondering whether there was a clear guideline of how much force is too much. What's the limit that a conciliator can go to?
That's a great question, Catherine. I don't have a formal answer for you. I can only talk anecdotally and from experience in that regard. But I think that's a great thing to research, whether that can be quantified in some way. But look, I think it is a question of degree, and I think it probably relies on the feedback that you're getting from the parties. If during that private session, the feedback that you're getting is that the party is becoming really submissive or defeated, then you've probably gone too far. So I think it's a matter of using your role positively and effectively, and being realistic, but fall short of crushing the participant by what you're saying. I hope that provides some degree of guidance, Catherine. But that's an interesting one to look into. Whoever it is that chooses conciliation for their discussion topic, that would be a really interesting avenue to consider. Thank you. Is there anything you wish to say on that, Catherine? Okay. Any other questions or comments?
Oh, that's good. That answers my question.
Great. Thanks, Catherine. Thank you.
Oh, John, I was just wondering, what happens if, say, one of the parties disagrees with the conciliator and they say, well, you know, the conciliator is taking a position that they just don't agree with, and they're kind of, I don't know, stuck with that. What do they do?
Again, that's a great question too, and I should have emphasised this. The conciliator is not there to make the decision, and has no capacity at all. Is there really as a friendly advisor for both sides, you know, the best friend for both sides. And because we can assume that the conciliator is acting in an unbiased manner and being procedurally fair, they're going to be exercising a degree of discretion, one hopes, and not make it such that the party believes that they must accept what the conciliator is saying. So the point is that it's still ADR, it's still a process in the hands of the parties, it's still their dispute. The conciliator is there to just take it up a notch and give them some advice, maybe, or give them some reality testing, but not take away the dispute. So it's still available for the parties to say, thank you very much, I appreciate what you're saying, but I don't accept any of it, and I'm going to negotiate as I see fit, or I'm going to go to the tribunal despite you saying that I don't have good prospects. I hope that answers it, John.
Yes, thanks, John. Thank you.
Yeah, great. All right, so what are the advantages of conciliation? Does anyone wish to offer any suggestions? What are the advantages of conciliation as opposed to mediation, as opposed to litigation or any other alternative? Advantages of conciliation.
You could ask the conciliator for his advice as to how strong your case might or might not be, whereas a mediator wouldn't be able to do that for you. You'd be going in blind. You couldn't ask him. He couldn't tell you.
Exactly. Thank you, John. That's spot on. So parties might be encouraged to go into conciliation because they're getting this free expert advice, typically, which might cost them a lot of money on the outside and might actually comfort them to know one way or the other. You know, you do have good prospects, or you don't have good prospects. At least you have a better idea. So thank you for that contribution, John. Appreciate that. Anyone else want to offer a suggestion on what is an advantage of conciliation? All right, well, the disputes might be resolved more quickly than other alternatives, such as a court hearing, certainly much more cheaply, probably less stress. Parties have a chance to make their own solution. Parties might have a chance to maintain good relations if they can sort it out themselves with the help of a conciliator. You know, a sense of achievement. We've done something here together. Maybe we're not totally happy with the result, but at least we sorted it out. So from an emotional, financial, economic, stress perspective, there are a whole range of reasons why conciliation might be regarded as a better alternative to litigation, for example. All right, now let's. I just want to highlight a couple of specific types of conciliation. I mentioned briefly QCAT. We call them compulsory conferences, but pretty much everything that we're describing under the heading of conciliation is what is covered in a compulsory conference. Family court. The Family Court of Australia, the parties can engage in a conciliation conference. Now that usually occurs after what we call the case assessment conference, and it's to do with financial disagreements, some parenting issues as well. An attendance at a conciliation conference in the family court jurisdiction is compulsory, and the instructions about how that conciliation conference will be conducted is usually provided to the parties at the case assessment conference stage. And if it's unsuccessful at conciliation, then of course, as you might expect, the matter will be listed for final hearing before a judge. So that's one specific type of conciliation. Another is Fair Work Commission. So in this instance, unlike the family law situation, attendance is voluntary It's not compulsory. It's often, this is for fair work, unfair dismissal. Very often it's done by phone. That's certainly my experience. It's quite informal, first names, we're going to try and resolve this thing. And this is unusual. Unrepresented parties who do come to an agreement are offered a 3-day cooling off period following that conciliation if they decide they wish to opt out of any agreed settlement. All right, contrasting conciliation and mediation is my next heading. I'll move through this fairly quickly because I think we've covered it. This is more in terms of, I suppose, a summary. Bearing in mind there's no one clear and definitive statement of a definition of mediation or conciliation, it's difficult, therefore, to say, here's the difference between the two. The waters are muddied. Sometimes they're almost merged, these processes. But if we look at them in their pure sense, they're very similar in that the dispute is resolved by a third party, a third party assists the parties to resolve the dispute. The third party is neutral. The mediator or the conciliator, as the case may be, will determine the process and control the process. So that's another similarity. Third similarity, they work towards a resolution or help the parties in that regard. Number 4, they hear from the parties. So again, that's common. Number 5, identify issues, generate options, consider alternatives, and endeavour to reach an agreement is number 5. Number 6, encourage the parties to communicate with each other in a confidential forum. Number 7, this is the last of the similarities, neither the conciliator or the mediator have a determinative role. So it's not up to them to make the decision. So they're the 7 similarities. Differences, attendance at conciliation is often compulsory. In its pure form, mediation is never compulsory, but often it is. Number 2, the conciliator can make an authoritative statement of the legal position regarding the dispute, that is the advice aspect, as an expert. Number 3, the conciliator may, now with great caution mind you, very gently interrogate or cross-examine. Do so guardedly because open questioning is still preferred, and that's the only way that you can really do it in mediation. But in a conciliation, you can have some closed questions. You can interrogate and cross-examine to a degree, but do so carefully because, as indicated, you don't want to crush the parties or feel that they have no say in the process. That could be useful if you're trying to generate options or reality test. The next difference between the two, the opinion of the conciliator may be imposed upon the parties. That is, the conciliator may make suggestions for terms of settlement, where the mediator will not do that, of course, in its pure form. Number 5, as the dispute resolution practitioner is proactive in intervening in conciliation rather than being passive, a participant as in mediation, it's appropriate for the conciliator to add agenda items in the discussion. We talked about that. And maybe guide the process a little more, or consider the context in which the dispute takes place. So, for example, in a family law dispute, the interests of the children always remain the paramount consideration. That's to do with any decision-making in relation to them. That's Section 65E of the Family Law Act. So, in that context, a family law dispute resolution practitioner in a conciliation may be called upon to champion the values of the statutory scheme, that is, advance that factor. And you can understand how that would work in practice, in that we have disputing parents ostensibly there to argue about their child, but really becoming distracted and arguing about things that don't relate to the best interest of the child. So in that instance, the conciliator should ensure that the parties are brought back to the values which are in the statutory legislation. Number 6, this is the difference between the two. The conciliator may more actively encourage the parties to reach a settlement than would be the case in mediation. Now, it's a question of degree, and a conciliator can be far more robust than a mediator. I guess it's fair to say lawyers that are trained in adversarial litigation do find it hard to be a mediator that's prepared to, not involve, not intervene. And so quite often lawyers will make better conciliators than mediators. Number 7 difference, the conciliator may give expert advice on likely settlement and the mediator does not. The options generated by the parties can be considered by the conciliator, and the conciliator may make comment as to the likely outcome. The mediator can only take a relatively soft option of asking the parties to reconsider their perceived benefits of litigation. The conciliator can do much more and actively state that a party's perception might be overstated or unrealistic, and go a bit further, or a lot further. And as we identified, the conciliator may actively suggest options for the parties, and maybe the parties haven't even considered those options. That shouldn't happen in a pure mediation sense. And we're getting pretty close now. Number 8, this is difference between the two. Where the conciliation does not result in an agreement, the conciliator can intervene by making directions or orders. So coming back to COCOs, as we call them in QCAT, compulsory conference, if the matter doesn't resolve, the member is expected to be making directions orders as to the future conduct of the matter, and in that sense, the orders are binding. So when I talked about the conciliator not being a decision maker, that's with this important exception, and that is the conciliator with power to make directions or orders can order the procedural conduct of the matter following an unsuccessful conference or conciliation to guide the parties and direct the parties on the process leading up to the hearing of the matter. Number 9, this is the second last one, that is the difference between the two. The role of the conciliator may be more specific. For example, there might be a very limited pool of conciliators in a particular specific area of practice. Now, that can be a good thing or a bad thing. It can be good in the sense that if you've only got 4 mediators in the state that deal with this specific type of dispute, then they can speak with real authority. But there is a danger in that the 4 of those conciliators can direct the proceedings away from, because they've got so much power collectively in a small group, they can direct the litigation or the dispute in a certain way, whereas that might not happen if there's a greater pool. And finally, the last difference I've got is the role of the mediator is to empower the parties, and whereas the conciliator may move between that power mode, that is taking the power, and empowering the parties. I think the point that was made before. All right, well, I've talked for well and truly long enough, and I'm just going to invite any questions or comments before I wrap up for this evening.
Would it be possible, please, to have a list of those differences and similarities? It would be quite beneficial because I can't find them in the textbook, laid out as well as you've just gone through them, or in your notes. Is that possible, please, John?
I'm sure. I'll post my notes.
Thank you very much indeed. It's very kind of you.
No, that's fine. Thanks, John. It'll save you some writing. Anything else?
Oh, hello. Yes, hello, John.
Yes, John.
I was just going to say that after you've listed all those differences and all the power that the conciliator has, that just seems like the ownership of the dispute, which is the hallmark of dispute resolution. That ownership really changes big time with the conciliator because they have kind of far-reaching powers. When you say they have the power to cross-examine and question, but they don't want to do it too hard. Well, who's going to be determining if they do it too hard? Maybe they've got a bad day. The potential for the abuse of that power just sits right there. So to me, I'm just making my student observations from my first contact with this, and I would just say conciliators have wide-reaching powers compared to a mediator who just doesn't have that.
Look, that's true, but I've probably given the wrong impression or overstated it myself. The powers are exercised, I think, on the whole, very carefully and cautiously. Let me give you an example of where perhaps a conciliation mode might be more advantageous than a straight mediation mode. We have a dispute between neighbours in relation to a tree and some problems associated with debris. It may be that the ideal solution is that one of the parties move their above ground swimming pool from directly below their neighbour's mango tree and relocate it on the other side of the block. Now, it might be that in the pure mediation model, the parties just never generate that option. It doesn't occur to them. And the ADR practitioner is just dying to say, well, look, if you pay for the relocation of that pool across to the other side, would you mind if your pool was on the other side? Then it's not going to have the leaves and you can all, coexist nicely. But without the power to intervene or ask questions or promote ideas or suggestions, these alternatives that might actually work sometimes result, the failure to provide them results in the matter not settling. So when I talk in terms of cross-examining, I really probably have misstated that terribly. What I should probably do, and I should delete it from my notes, is just say question, not cross-examine. So in that private session in reality testing, you might be able to say, look, have you ever thought about moving the pool across to the other side? Now, maybe that's cross-examination, but it depends on how you do it. It's really gentle questioning and prompting and promoting. That's probably a safer, more accurate way to describe it, John. But I'm really pleased that you raised it, and I hope that answers the question.
Yes, I can see that you have the view of the potential for good with power, and I always scared about the potential for abuse. So that's why I immediately sort of bring that up. But I can really understand in like today's society where we just don't have the time perhaps to do the pure mediation model. And if, a practitioner had more power at their disposal, they could ask questions that were begging to be asked and would help facilitate the process. Yes.
Yep. No, thank you for that comment. And you could probably tell I'm a bit of an advocate for the conciliation conference, but being a litigation lawyer, you do tend to be a bit that way. So thank you, John. Any other questions or comments? All right, nothing on the chat. We might end the meeting, and we look forward to seeing you next time. Bye.
Thanks, John.